Hello, and thank you for visiting Graphene Business Law. If you're watching this video on YouTube, go ahead and click on the red subscribe button down below. Graphene Business Law is your go-to platform for business law services for entrepreneurs and small and medium-sized business owners and operators in Toronto and beyond. And we'll regularly be posting content here on YouTube that speaks to your areas of interest as an entrepreneur or small or medium-sized business owner or operator. My name is Pamela Mitani, and I am the principal lawyer and founder here at Graphene Business Law. Today's topic is one that is timely given the difficulties of COVID-19 experienced by business owners, but also one that speaks to a very strong business law tool, and that is bankruptcy and insolvency. Bankruptcy and insolvency in Canada is operated under a federal regime and governed by the Bankruptcy and Insolvency Act. In today's video, as an introduction to that world of bankruptcy and insolvency, I will be speaking to two sections in particular that, whether you're a debtor or a creditor going through that journey, you will benefit having some basic understanding of, and two sections that I suspect you will definitely come into contact with as part of the bankruptcy and insolvency journey. That first section is what is known as the Solvency Test, or one that speaks to those triggers of insolvency that might position you in a way that you start that journey of bankruptcy and insolvency. Specifically, I'm speaking to Section 2 of the Bankruptcy and Insolvency Act. I'll read the section out loud so that I don't miss any words, but insolvent person is defined in the BIA as a person who is not bankrupt and who resides, carries on business, or has property in Canada, whose liabilities to creditors provable as claims amount to $1,000 or more. And there are three trigger points here for insolvency. What I want to point out is that in addition to that basal $1,000 plus claim, these trigger points are not cumulative, so not all three need to apply. Either of them or any of them applying will do. That first point is a person who is, for any reason, unable to meet their obligations as they generally become due. The second trigger point is that person who has ceased paying current obligations in the ordinary course of business as they become due. Or the third trigger point is that person whose aggregate of all of their property is not at fair market valuation sufficient to cover the liabilities that under that person's financial profile. Important to note here is that person can be an individual, otherwise known as you, as the human being behind the camera, as business owner or operator, or it can also be a business. Both of those entities or beings can be considered persons under the Bankruptcy and Insolvency Act. And there's of course certain dollar thresholds when we're dealing with the business side of things, because for higher dollar amounts, we would turn to the CCAA for those larger organizations with larger amounts due and larger debt amounts. Another point that's important here that you should definitely know if you are contemplating this bankruptcy and insolvency journey, and if this is the first time you're hearing this vocabulary on the matter, is that if you're a debtor, you can be petitioned into bankruptcy. What does this mean? And this is a really significant point to understand. It's not the case that if you as John Smith or you as the corporation owe someone money, you can wait for months and months or years and years and see how things go and not have that risk of somebody else deciding, hey, it's time to collect. You owe me over $1,000 and you've met one of these three trigger points. So someone else, known as a creditor, can petition you into bankruptcy if they're on the other side of this equation where they are owed over $1,000 and they have that argument that you are able to meet one of these three trigger points. For example, you owe that other business over $1,000 and they feel that you can't meet your debts as they come due. So that's really important to understand as a big picture item of the bankruptcy and insolvency regime in general, but certainly one from those first steps of understanding what triggers bankruptcy and insolvency. Another section I'll speak to in this video, and I want to keep the video digestible. I won't speak about every section in the Act. The Act is quite a lengthy one, and despite that, there is case law behind most of the points in the Act. There's arguments going multiple ways. Things can get very complicated very quickly. However, for the purpose of that introduction to that journey, the other section I want to speak on is the payout scheme. Certainly, if you're a creditor, this is a section you'll be extremely interested in and perhaps most interested in. And if you're a debtor, you will also want to have an understanding of where those assets of yours once dealt with, once sold off, for example, in whose hands they'll fall in and at what order. So now we're looking at section 136 of the Act, the Bankruptcy and Insolvency Act, which speaks to this scheme of payout. And I will clump together most of what is said in that Act, again, to keep it very digestible. There are certainly tangents coming off of each of these categories. But big picture, secured creditors are going to be paid first. They are so much a priority under the bankruptcy and insolvency regime that some on the matter will actually say that secured creditors fall outside of the scheme of bankruptcy, outside of the section altogether, because they have such a special position. If you are a creditor, however, again, this video is packed with those important pieces, but another very important item you'll want to be aware of is that you can, as secured creditor, fall back into the regime of payout that everyone else, all the unsecured, fall under if that item on which you have registered your security is sold off for less than was owed to you. For example, if you're a secured creditor who has registered that $100,000 security on an item, let's say, and the item sells off, the trustee sells it off under the regime for $50,000. Well, now $50,000 is owed to you. And insofar as this amount is owed to you, because that good on which the security was based on is no longer around, is no longer securing your debt, now the rest of it falls under the general schema of unsecured creditors. So moving forward with the section 136 and the payout scheme, first is going to come those reasonable, funeral and administrative costs, testamentary expenses having to deal with a deceased person who's been involved in this bankruptcy and insolvency journey. Second is going to come administrative costs related to the professionals dealt with helping you navigate the journey. For example, trustees, that's certainly somebody you'd be coming into contact with by means of professionals involved in bankruptcy and insolvency in Ontario and Canada. Third is the levy on dividends paid to secured, preferred, and unsecured creditors. Fourth is a big clump of priority creditors, and this can include certain employment claims, it can include landlord claims, it can include municipal taxes, just a variety of claims that have been deemed priority by the regime. And last, of course, is unsecured creditors with no unique attachment to property. So going through this scheme helps you understand some of the players that will be involved in your bankruptcy as well. If you're on the debtor side, and on the creditor side, it can give you also a big picture understanding. If you are an unsecured creditor with no attachment to any unique property, I would warn against expecting 100 cents per dollar that is owed to you, because that may not be the case, and oftentimes it is not the case. To recap, we've talked in this video about two sections that are crucial to better understanding the bankruptcy and insolvency landscape, and one is that very first, or one of the first sections in terms of what triggers that journey, and the second section being, once we get near the end, who is paid out and in what order. As a legal professional, as a lawyer and a business lawyer myself, it is crucial for me to pause here and mention a few of the background pieces to those undergoing bankruptcy and insolvency proceedings. Bankruptcy can be a time fraught with emotions, tensions, difficulties logistically or personally. It can be an overwhelming time for many. However, what bankruptcy does not need to be is a shameful time or an embarrassing time or something that you are so darkened by in your personal life. Certainly, bankruptcy proceedings can take a toll on your personal life, and this can include, unfortunately, family, it can include business partners, whatever the case may be, whoever those key players are in your personal life in addition to your business life. However, there is no need to have stigma attached to bankruptcy proceedings. As a lawyer, a bankruptcy lawyer, bankruptcy law is a passion spot of mine, and I look to bankruptcy law and bankruptcy proceedings as one of the strongest tools in your repertoire as a business owner and operator, and certainly as a business itself. Undergoing bankruptcy proceedings can be the best thing to help you or your business get to healthier pastures. And I feel that that's a really healthy way to look at the process. You are employing a tool that can help you get to healthier pastures. So that being said, anytime you can call us here at Graphene Business Law. We are knowledgeable on the topic of bankruptcy. We have experience with bankruptcy matters. And as I mentioned, it is in fact a passion spot for us here at Graphene to help business owners, because the reality is that most businesses are going to have that life cycle of launch and growth and conclusion. And conclusion can oftentimes mean restructuring or bankruptcy and insolvency proceedings. And insofar as it means the latter, we are here for you with open doors at Graphene Business Law. You can contact us anytime for issues on the trigger points of bankruptcy, for consumer proposals, for commercial proposals, issues with undergoing any part of the process having to do with certain creditors, trustee, classes of creditors, whatever the case may be. We are here to help you with your bankruptcy journey. So you can contact us anytime at info@graphenebusinesslaw.ca. You can book a consultation anytime on our website, graphenebusinesslaw.ca. And if you're in Ontario, you can also text us anytime, 647-466-5985. Thank you for watching.